The Honorable Court of Appeals is now in session.
Good morning, lawyers. Before we call the case, just a couple of things. If we should have any technology problems, don't worry about it. We'll simply take a pause and work them out. When I say we'll work them out, that means our experts, deputy clerks, and AOC IT people will work them out. Call the case, please.
Matthew Keith Hubbard versus Claiborne County Board of Education et al.
We'll hear from the appellate.
Good morning, Your Honor. Rick Colbert, I represent the appellant Keith Hubbard. And I'd like to reserve 2 minutes for rebuttal.
That'll be fine.
This is a challenge under the tenure law to the dismissal of a career educator. The main characters in the scenario that led to Mr. Hubbard's dismissal were Mr. Hubbard, his wife Pam, and a third individual, Glenn Smith, all of whom were teachers in the Claiborne County school system. Mr. Hubbard found out.
Mr. Colbert, I'm sorry. Ms. Dempsey, can you work it so the time clock is showing?
Yes, sir.
Thank you. I'm sorry, counsel. Go ahead.
That's right. Mr. Hubbard found out that his wife Pam was having an affair with Glenn Smith. He confronted her about that affair, and she left home with their 2 children and went off to an undisclosed location. This was over a weekend, and Mr. Hubbard was distraught. He was trying to reach her. He couldn't reach her. He sent her text messages. And in a text message that was introduced in the record, he made a comment that he he used an expletive, but he said he wanted to beat up Mr. Smith, the man with whom his wife was having the affair. Nothing came of that. His wife knew from years with Mr. Hubbard that it was bluster. It wasn't a true threat. And eventually they got back together. A month later, on October 4th, 2018, Mr. Hubbard went to pick up his son at Midway Elementary School after basketball practice one evening. And it just so happened that this same Glenn Smith was the basketball coach. When his wife Pam found out he was on his way to the school to pick up his son, she panicked. She rushed over to the school, banged on the door. She told Mr. Smith that Mr. Hubbard was on the way over, and then Mr. Smith panicked and had his assistant coach call 911. The police came, they locked up the gym, and there was a big furor. Nothing occurred, but the furor led to an investigation by the director of schools and ultimately to charges against Mr. Hubbard, on which he was dismissed, a charge of insubordination based on a warning he had received the previous April after he got a DUI. And a charge of unprofessional conduct. And the hearing officer found him guilty. The board found him guilty. Well, the board dismissed him, and the chancellor upheld that dismissal. And this is our appeal from that ruling by the chancellor. Under 49.
Did Mr. Hubbard actually send, or does the record reflect that Mr. Hubbard actually sent threatening emails or texts to Mr. Smith?
He acknowledged on questioning from the hearing officer that he had sent texts to Mr. Smith the same evening.
So that same early September 2018.
Same early September, when he was trying to find his children, and Mr. Smith wouldn't respond to the texts.
Okay.
He never actually spoke to Mr. Smith.
Okay. Any text after that or threats after that? Okay.
No, there's no evidence of anything after that. In fact, the hearing officer said something, I can't remember his exact words in his ruling, but he basically said, we moved forward a month and nothing has happened. So nothing occurred after that one evening. Under TCA 49.5.513G, the legislature has contemplated that the dismissal of a tenured teacher can be challenged on 2 bases. It can be challenged on the facts, but it can also be challenged if the board acted arbitrarily or in violation of the teacher's statutory or constitutional rights. This challenge is on both of those bases. And first, I'd like to talk about how the board acted arbitrarily and in violation of Mr. Hubbard's statutory rights. In our view, the board did that in three ways. The first way was through the introduction of evidence in the dismissal hearing that was beyond the scope of the charges. Mr. Hubbard had a problem in 2014. He acknowledged to the hearing officer that he had an alcohol problem. And in 2014, he had an arrest for a DUI, but that was not mentioned in the charges anywhere. There was mention of a 2018 DUI in the charges that formed the basis of the, I think ultimately formed the basis of the insubordination charge because of a warning that the system gave him when they suspended him for 3 days then. But there was nothing in the charges about this 2014 offense. TCA 495511A4 says the charges must specifically state the offenses charged. And there are two Tennessee Supreme Court cases that have construed that language, Potts versus Gibson in 1971 and Turk versus Franklin Special School District in 1982. And both those cases say that the charges must specifically state the offenses with substantial certainty. And in Turk, the court said it was fundamental error to consider wrongs not specified in the charges. And that case actually also, by happenstance, involved a prior DUI that was not mentioned in the charges, but was brought up at the hearing. In this case, the board's lawyer at the dismissal hearing introduced evidence of the 2014 arrest, and it wasn't in the charges anywhere. It was objected.
Counsel, how was it used? Was it related to the 2018 arrest, the way it was brought up?
Well, the explanation by the board's lawyer was that he wanted to introduce it to show that Mr. Hubbard knew that conduct outside of the school setting could still be regarded as unprofessional conduct. But that explanation sort of defies logic, because the 2018 incident that was in the charges was that he was suspended for was for conduct that occurred outside of the school setting. And Mr. Hubbard never denied that conduct outside the school setting could be regarded as unprofessional conduct.
All right, so the 2018 charge had already resulted in a year's suspension.
A 3-day suspension.
Three-day suspension, I'm sorry. Okay.
Yeah. I mean, that had already happened the previous April. And so there was never a question about whether outside conduct could constitute unprofessional conduct. And in the end, the hearing officer and the chancellor used it for much more than what the board's attorney said he was offering it for. The hearing officer relied on it in his determination that Mr. Hubbard was guilty of unprofessional conduct and insubordination. And the chancellor relied on it in paragraph 2 of her findings and paragraph 7 and 14 of her conclusions of law for the ultimate decision she reached. So,
Mr. Colbert,
yes.
Let's just say that we go with that argument that, and I understand that the school board has a different position on the purpose of the 2014 issue and how it was used, but assume that we find that it was inappropriately admitted and inappropriately used. Can we still, though, affirm the ultimate decision based on the fact that even if you put that aside, just the evidence of the threats that he made by themselves subsequent to that 2018 DUI were unprofessional conduct?
Well, I mean, I don't think they were unprofessional conduct. I think if the court does that, then the court is really disregarding the language of 495513, which expressly contemplates that the teacher can offer evidence that the board acted arbitrarily or in violation of his statutory or constitutional rights. I mean, if there's been a clear violation of Mr. Hubbard's statutory rights, I don't see how the dismissal can stand. I don't think the court can just treat that as harmless error, and especially in the context of this case, when that's not the only way in which the board disregarded the statutory requirements.
So you say we can't treat it as harmless error. So what was the error? I mean, how did that error impact your client below that evidence came in?
Well, it affected the outcome of the case below. It affected the hearing officer relied on it on the 2014 incident for his findings that Mr. Hubbard was guilty of insubordination, and the chancellor relied on it for her determination that he was guilty of insubordination and unprofessional conduct. So it wasn't simply introduced, it was relied on in the decisions, in both of the decisions that were made based on the evidence. Now, the second way that the board, we believe, acted contrary to statute was that when the board reviewed this matter after the hearing officer decided it, the board did not concur in the charges. This court decided a case a number of years ago, Winkler versus Tipton, the Western section decided a case, Winkler versus Tipton County Board of Education. And in that case, they said that a finding of guilt by the school board is not necessarily inherent in imposing punishment. And particularly in that case, like this one, there were two charges, one of insubordination and one of unprofessional conduct. And the court said where there are two charges like that, the failure of the board to make a finding of guilt on one charge or the other leaves the reviewing court unable to determine whether the board actually found him guilty or not. In this case, we noticed the board's deposition because the board had simply voted to uphold the hearing officer's decision. So we noticed the board's deposition under Rule 30.026. And the first subject in the notice was the specific cause or causes for which the board voted to dismiss Mr. Hubbard when it reviewed the hearing officer's decision. The board's attorney responded that there was no one who could be designated to testify for the board about that, and that each individual board member would have to speak for himself or herself. And so we deposed all 6 board members. That was our deposition of the board. And what we found was that there was actually no concurrence by a majority of this 6-member board about what charges Mr. Hubbard was guilty of.
Well, no concurrence except their vote in favor of upholding the discipline.
There was a vote in favor of upholding the dismissal, but there was no concurrence about why. There were 3 board members, but that's half, that's not a majority, who relied on this supposed threat to Mr. Smith as the basis for their decision. There were 2 others who simply went along with whatever the hearing officer said and expressly did not rely on the threats. So without a majority concurrence on the charges themselves, the board really should have overturned the hearing officer's decision on that review, but they didn't. They simply voted to uphold it without the required concurrence by the board on the charges. And finally, there was no independent decision by the hearing officer or the board on whether dismissal was the appropriate result. The hearing officer deferred to the board, although the board hadn't made a decision yet, and the board simply took 3 members of the board simply took the recommendation of the hearing officer and didn't make their own independent decision that dismissal was appropriate. I'd like to keep my 2 minutes for rebuttal, if I may.
You have your time for rebuttal. We'll hear from the appellee.
May it please the court. I'm Janet Hayes. I'm here today on behalf of the Claiborne County Board of Education and the other defendant appellees. This case is about an educator's attempt to manipulate the Tennessee Tenure Act to avoid responsibility for his conduct. The Tenure Act does not provide a guarantee of future employment. In fact, the Tenure Act specifically denies protection when an educator engages in conduct that is unbecoming a member of the profession or conduct that is insubordinate. And Mr. Hubbard engaged in both. Now, as Mr. Colbert explained, his arguments are sort of grouped into two different buckets, if you will. He's made substantive arguments saying that Mr. Hubbard did not engage in unprofessional or insubordinate conduct. And then he's also made what I'm going to characterize as procedural arguments, claiming that there was somehow a violation of the statute. I'm going to address the substantive arguments first, and then I'll get into the procedural issues. With regard to conduct unbecoming a member of the teaching profession, the Tenure Act, as you're aware, spells out a non-exhaustive list of things that could be considered conduct unbecoming. But this court also in Way v. Hall has said that conduct unbecoming can be any conduct that has a negative effect on the school system. If we look only at what Mr. Hubbard admitted, just at what he said he did, and what he himself testified was conduct that was unprofessional. He admitted that he received the DUI in 2018. He admitted that he sent 5 or less threatening texts directly to his coworker, Coach Smith, and admitted those were unprofessional. He admitted that he verbally threatened his coworker. He admitted that he sent a text to his wife saying, quote, "I know exactly where he lives and I will be waiting." He admitted that he sent a text to his wife saying, "I'm going to confront him," again, referencing his coworker. He admitted he sent a text saying, "I have a place for Glenn," and that he sent a text saying, "I know where he lives and works." And with each of those admissions, he admitted that that was unprofessional conduct. So I think it's very clear based on his testimony alone that he engaged in unprofessional conduct. But if we look beyond his testimony, I don't think we can ignore the events of October the 18th. Now, his argument is, well, they overreacted. The coach and his wife, they overreacted, and that he didn't really intend to do anything. That is certainly questionable based on the facts of what his intent was. But I think if you look at his history of conduct, they reacted very appropriately given his history of threatening behaviors. And that history of threatening behaviors then led to a school shutdown and a lot of fear at that basketball practice and a principal being called in.
How much time had passed, counsel, excuse me, how much time had passed between the emails and that incident at the school, the basketball practice?
Mr. Colbert was correct that the emails, I think, or text messages were primarily in September, and this primarily occurred in October. I don't think it is incorrect to say that nothing had happened in that time or to suggest that there was no tension in the interim in between those events. Did they work together, the coach and the husband here, the plaintiff? They worked in the same school system. They did not work in the same school.
So everybody in the school system is a coworker? Well,
I certainly think that Mr. Hubbard and Mr. Smith would be deemed co-workers. They worked in the same system. They knew each other. And also Mr. Hubbard's wife worked in the system as well.
So your position is that everybody in that school system, they're all co-workers, so that anything that happens between two people employed by the school system outside the school involves co-workers.
Correct. Yes.
Okay.
I think, in addition to the events of October 18th, with regard to unprofessional conduct, we can't ignore that the statute also points to the teacher code of ethics and says that any violation of the teacher code of ethics is unprofessional conduct. The teacher code of ethics specifically prohibits or specifically requires a devotion to excellence. It requires a desire for the respect of one's colleagues, and certainly Mr. Smith would be considered a colleague, of students, parents, and members of the community. So Mr. Hubbard's position has been that his threatening behavior was understandable. I think he said in his brief, given that his wife was having an affair, it was an understandable. I take issue with that. While being angry may be understandable, threats of violence against a colleague is not understandable and is not okay. In addition to the unprofessional behavior, he was also charged and terminated based on insubordination. Insubordination is a violation, according to the statute, a violation of a law or failure to comply with rules and regulations or failure to carry out specific assignments made by the board or the director. As has already been mentioned, Mr. Hubbard had a DUI in April of 2018. At that time, the director of schools met with him and gave what everyone agrees was a clear directive for him not to engage in future unprofessional behavior. And then just a few months later, we have the events of October the 8th. His position in his brief is basically that, well, the director told me not to engage in that unprofessional behavior. The director didn't tell me not to engage in this unprofessional behavior, which I think is a misplaced argument.
You say October 8th, you mean October 4th, 2018?
I'm sorry. Yes, Your Honor.
Okay. So if Mr. Hubbard had just been driving, not to the school, but just driving and pulled over for a revoked license, would that have triggered the same charges? Or did it have to be going to the school to pick up his child?
I don't know I don't know what charges that would have triggered. I think what is relevant here is the totality of the circumstances, the threats that had been made, coupled with the behavior on that evening in question.
Had Mr. Hubbard been warned by any superior not to be around Mr. Smith?
He had not at that time. He had been warned extensively about unprofessional conduct. I'm not aware of a specific warning directed toward Mr. Smith at that time. It was the investigation of the events of that evening that uncovered all of the threatening texts about Mr. Smith.
There was a mention of a verbal threat made by Mr. Hubbard to Mr. Smith. When did that occur?
That was in the text message. I'm sorry.
Oh, in the text message. Okay.
The other category of arguments, what I characterize as procedural arguments, I would like to specifically address the argument that Mr. Claiborne made about the 2014 DUI. Mr. Hubbard has taken the position that the 2014 DUI, that it was an error somehow because it was not identified in the charges. But it is very clear that this case, he was charged based on conduct that occurred in 2018, and he is being punished based on conduct that occurred in 2018, not what happened back in 2014. And certainly the 2014 DUI was mentioned. It was introduced in the hearing before the hearing officer, but the hearing officer specifically addressed it in his decision and found his exact words were, with regard to the 2014 DUI, the ship has sailed on this incident and Mr. Hubbard cannot now be disciplined. So he made it very clear that the discipline that he was invoking was based on the 2018 conduct, not the 2014 DUI. Similarly, the chancellor in her decision, she mentioned in her findings of fact that there had been a 2014 DUI, but stated that he had been, quote, given an admonition, which was the punishment for the 2014. She went on to specifically in the findings say the threats to a coworker is the unprofessional conduct at issue. She did not reference back to the 2014 DUIs forming the basis of her decision. She also said failure to follow the directive of the director of schools to avoid future issues is the basis for insubordination. So I think she made it very, very clear, as did the hearing officer, that any evidence of a 2014 DUI did not form the basis for the current charge of insubordination or conduct unbecoming, and was not the basis for dismissal. Mr. Colbert mentioned the Turk decision, Turk versus Franklin County Special School District. And actually in his brief, he says that this case is on all fours with Turk. And I take issue with that. I don't think it is at all. In the Turk case, a teacher was charged with a single DUI and was dismissed based on the only thing in the charge being a single DUI. However, at the hearing, the school board introduced evidence of her attendance record, evidence regarding a prior automobile accident, evidence that she may have a drinking problem or need counseling for alcoholism. That is very, very different than what we're looking at in this case. And in fact, in Turk, the court said, and I quote, stripped of the other charges, it, the lone DUI, would not have supported dismissal of a tenured teacher. So in Turk, what was in the charges didn't support dismissal. In this case, what supports dismissal is exactly what was in the charges. And what was in the charges was the 2018 DUI, as well as the threatening behaviors that all occurred in 2018. So I think the reliance on the idea that the 2014 DUI should have been mentioned in the charges is completely misplaced. Also, there's an argument, Mr. Colbert has suggested that there was not a consensus on the charges and the decision. And if I understand his argument correctly, I think he's sort of making a two-pronged argument. He first says there wasn't a consensus on both the charges and the decision. But if you look at what actually happened, and I urge the court to look at the record of exactly what happened, the minutes of the board, which are the voice of the board, very clearly show a vote that was 6-1, and the vote was on a motion to, quote, sustain the hearing officer's decision. Now, admittedly, they didn't say sustain the hearing officer's charges and decision, but if you look at the hearing officer's decision, it very clearly states what the charges are. The hearing officer's decision says, and I quote, the hearing officer found Keith Hubbard's threats of violence to Glenn Smith constitute unprofessional conduct. Keith Hubbard's threats of violence to Glenn Smith, when considered in light of his previous disciplinary history, constitute insubordination. The decision to discharge as an employee of the Claiborne County Board of Education is appropriate under the facts and circumstances. So the hearing officer found guilty of insubordination, first charge, guilty of unprofessional conduct, second charge, and that termination was warranted.
But they also talk about disciplinary, please.
No, go ahead.
They also talk about disciplinary history, and that disciplinary history necessarily includes the 2014 DUI, does it not?
We don't know that it includes that. I think the disciplinary history could be referencing the 2018 DUI, which was the clear directive. That is the disciplinary history that both the hearing officer and the chancellor both specifically mentioned as being part of their thought process. I would not assume that that necessarily encompasses the 2014 DUI. The only other point, and also with that point, Mr. Colbert has suggested there was not a consensus. And again, Mr. Colbert did depose every board member, and every board member, of course, talked about different evidence, talked about different thought processes they had, but every board member agreed with their vote. No board member testified that they should have changed their vote, or they were mistaken in their vote, or they wish they'd voted differently. It was a 6-1 vote, and no one changed their position. So I don't know how we can say there was no consensus. I'm sorry.
I'm sorry, counsel. Did they testify? Some of them testify why? Or I voted because of the threatening emails. I voted because of the insubordination. Or was there testimony on that from the board members?
Yes, certainly. Mr. Colbert would ask perhaps an open-ended question, why did you vote the way you did? And a board member may respond in a certain way. Now the argument is, well, because each board member didn't cite the exact same thing, there was no consensus.
Well, in fact, they cited different things, didn't they?
Well, one board member, when asked, why did you vote a certain way, one board member may talk about the threatening behavior. And then the questioning moves on to something else. Another board member may talk about the DUI, but that doesn't mean they didn't consider all of that. They talked about different things that made impressions on them.
Well,
But
they answered his questions, didn't they?
Yes, they did. And they all agreed that Mr. Hubbard engaged in unprofessional conduct and insubordination.
They just don't necessarily agree on what that was, whether it was by their deposition testimony, whether or not it was the threatening emails or the 2018 DUI or whatever.
I likened it to a jury being questioned after the fact and saying, why did you vote the way you did? And different jurors rely on different pieces of evidence as being persuasive. If I'm seeing that my time is up, I would just like to conclude by reminding the court and reiterating that the standard of review is that there's a presumption of correctness with the chancellor's finding of fact, and I have not heard anything to overturn that presumption of correctness. And I would just urge the court to look at what happened in this case. The board and the hearing officer and the chancellor all followed the mandates of the Tennessee Tenure Act. They did exactly what they were supposed to do, and afforded Mr. Hubbard every protection he was entitled to. It's now time that he accept responsibility for the consequences of his own conduct, and therefore I ask that you affirm the decision of the chancellor.
I lost.
Yeah, did we lose Judge Sweeney?
I think we lost the chief there for a second. If you'll hold on, counsel.
I hope I'm not losing my rebuttal time in the process.
No, you're not. You're not.
As soon as he shows back up, I will let him in.
All right. Thank you, Jared. I'm glad it was the chief that made the mistake instead of me.
Hey, I didn't make a mistake. It's technology. It's like Gus Grissom said when the capsule sank when he landed in the ocean. I was just sitting there and the hatch blew.
Likely story.
Yeah. So, counsel, I lost you all right at the when you were doing your conclusion. You want to redo it, please, for me?
Certainly, Your Honor. In conclusion, I would just reiterate that the findings of fact afforded or found by the chancellor are afforded a presumption of correctness, and that certainly has not been rebutted. And I would also urge the court just to look at the record in this case and see exactly what was done, because both the hearing officer and the board followed the statute, both the letter and the spirit of the law. Mr. Hubbard was afforded all of the protections he was entitled to under the Tennessee Tenure Act. And it is time that he now accept responsibility for his conduct. So I ask that you affirm the Chancery Court.
Thank you, counsel. We'll hear from the appellate rebuttal.
May it please the court, when this dismissal hearing started out, the board's lawyer said he was going to prove that Mr. Hubbard went to the school on October 4 to beat up Mr. Smith. There was absolutely no proof of that at the hearing. And so what we're left with is a dismissal on the basis of unprofessional conduct because Mr. Hubbard sent some text messages to his wife and the guy that she was having an affair with at the time that she had run off with his children. In Morris versus Clarksville Montgomery County Board of Education, the Court of Appeals said, and in Turk versus Franklin Special School District, the Supreme Court noted that the effect, when you're talking about off-duty conduct, the effect of the teacher's conduct on the school is an important element in determining whether it meets the statutory definition of unprofessional conduct and whether it justifies a dismissal. In this case, the only evidence there is about the effect on the school is that there is none. There were 4 teachers who testified at the hearing. Mary Barker, Paula Goins, Misty Cooper, and Tim Muncie. They all worked with Mr. Hubbard. They knew his wife was a serial adulteress. They knew that he kept his problems away from school. He was an excellent teacher, and they didn't regard this as anything affecting his ability to teach effectively. So there's no evidence in the record that this episode that happened in September of 2018 of him sending text messages adversely affected his ability to work. As far as insubordination goes, that started out to be based on the driving on a revoked license charge that was later dismissed. And at the start of the hearing, the board's lawyer started to drop that charge, but then they tried to shoehorn it into the 2018 warning about similar incidents, which is certainly not the type of specific assignment or specific direction that the definition of insubordination calls for. And finally, I do just want to point to the record. If the court looks at the hearing officer's decision, he said in the record at volume 1, pages 10 and 11, that the 2014 arrest was relevant to Mr. Hubbard's overall fitness to serve and to both charges. And the chancellor in her conclusion number 14 said she considered prior warnings and disciplinary actions plural for her decision that dismissal was the appropriate result. Yet there was only one prior warning in the charge, and that was the 2018 warning.
You used your time, counsel.
Thank you.
Of course, thanks to both parties. We appreciate your arguments. The issues are clear, and we appreciate your time. If you would, Ms. Dempsey, please recess court until 1:30 this afternoon.